everyone, and welcome to Row and Limbo, a town hall on the leaked Dobbs opinion. My name is Carmel, Shachar, and I'm the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School's Executive Director. I think this is going to be a really fascinating conversation, but before we get to the substance of the matter, I want to go through a few logistical details. First of all, this is a town hall, so not only are we open to your questions, we strongly encourage them. I would love if the questions we ask our speakers are more your questions than my questions. If you'd like to submit a question, please use the Q&A feature found in the meeting controls at the bottom of your screen. Submit it at any time. I'll be continually monitoring the Q&A queue and pulling out great questions. If you'd like, you can join the conversation or submit questions on Twitter. We're at Petrie-Flom, and you can use the hashtag #RowInLimbo. Again, hashtag #RowInLimbo. If you put a question there, we'll pull it and put it into the Zoom Q&A. On the other hand, if you have technical issues, and I sure hope you don't, please email petrie-flom@law.harvard.edu. Again, that's petrie-flom@law.harvard.edu. We will be sharing the fully captioned event video with all registrants between 1 to 2 weeks. So you'll get an email saying the video is now up. Please share it widely with your friends who weren't able to make it today. If you like what you see here, I strongly recommend that you sign up for our newsletter, which comes out only twice a month. That includes scholarship. For example, we're going to have a roundup of the really wonderful scholarship happening on our blog, Bill of Health, especially our symposium on adoption as framed as an alternative to abortion. Or you can check out our upcoming events. We have another one coming up a week from Friday, looking at the fate of vulnerable individuals in the next phase of the pandemic. So please keep in touch. Please come to our future events and follow our work and our scholarship in our newsletter and the blog. With that being said, we've gotten our housekeeping out of the way. I will say that I was extremely shocked when I got that Politico email saying that there was a draft opinion for Dobbs versus Jackson's Women's Health Organization. I actually thought that it was a prank because I thought, wow, Supreme Court opinions are never leaked, and this one reads so very strongly in one direction that it felt almost perhaps a bit of a parody or somebody trying to imitate where they thought the Supreme Court might go. That being said, my initial impulse was incorrect. It is indeed a leaked draft opinion of Dobbs. We won't know how closely the finalized opinion used to the leaked draft until they announce it, of course, but it is likely to be very relevant. Because we're in such an interesting moment in time, the leaked opinion, I think, will really radically reshape the right to reproductive freedom in this country. We wanted to gather 2 experts on the topic to have a town hall chat of the implications of this draft. And so with that, I would like to welcome Glenn Cohen, who is the Petrie-Flom Center's Faculty Director, but also the James A. Attwood and Leslie Williams Professor of Law and Deputy Dean at Harvard Law School, as well as Mary Ziegler, who's the Stearns Weaver Miller Professor at Florida State University College of Law, as well as a visiting professor at Harvard Law School. Glenn, Mary, welcome. Thank you for coming and providing us some context. I think everybody on this Zoom has likely heard, oh, there was a leaked opinion from the Supreme Court, and it was the Dobbs case, which is the next big abortion case. But for those who don't have access to Politico and haven't read the opinion itself, could one of you give us a brief summary of the proposed opinion?
Professor Ziegler, maybe I'll let you do it since you've been on TV quite a lot having to do the exact same
thing. Yeah,
I'll
just do it one more time. Yeah, so the The draft opinion holds that Roe v. Wade was not just wrong, but egregiously wrong in the language of the opinion, wrong the day it was decided and wrong today. Its reasoning draws heavily on Washington versus Glucksberg, right? So it asks whether a right to history is deeply rooted in the nation's history and tradition, and concludes that that right is not deeply rooted. The draft suggests that from the very early common law onward, abortion was viewed, if not as a crime throughout pregnancy, then certainly with disfavor, that there was no belief in the 19th century at the time the 14th Amendment was ratified that there was a right to abortion, and that indeed most states at the time were criminalizing abortion throughout pregnancy. And there's some kind of in the weeds details about how and why, but that the opinion takes on as well. The draft also looks at kind of conventional stare decisis analysis, in addition to leaning pretty hard on the idea that Roe was egregiously wrong, that its reasoning was uniquely unpersuasive. The draft suggests that Roe and Planned Parenthood versus Casey have become unworkable. As evidence of this, the draft looks at the fact that the court has tinkered with Roe and Casey, and also that the undue burden test, which Casey laid out, has uncertain contours that the court's justices don't necessarily, even at the moment, agree on what it entails, and that it's generated inconsistent results in the lower courts. With respect to reliance, the draft mostly harkens back to an earlier idea of reliance that looks only at whether people had advanced planning vis-a-vis abortion, and concludes that that kind of reliance analysis doesn't support Roe and Casey, although in passing in footnotes, it gestures to the idea that maybe even the kinds of reliance interests, kind of the idea that people who can get pregnant have achieved more equal lives by relying on the availability of abortion, that maybe that isn't true either, because norms surrounding adoption have changed. But mostly the opinion, draft rather, adopts a view of reliance that is an older one that had been, I think, if not rejected, then certainly transformed by Casey in 1992. And the draft rather spends a lot of time on the so-called abortion distortion argument, the idea that in saving a right to abortion, the court had modified in deeply unfortunate ways rules on things like standing, and that too is an indication that Roe and Casey had been wrongly decided. The draft also directly takes up the question of whether overturning Roe, or even overturning Roe in precisely the way the draft proposes to do, will undermine the court's legitimacy. And Justice Alito there essentially says two things. First, that he's not, and the court is not in a position to evaluate whether an opinion would damage the court's legitimacy, and that even if the court had the institutional competence to make that kind of judgment, it would not be the job of the justices to care if their rulings are deeply upsetting to people. So I think that's a sort of broad overview. There's another interesting piece is that while the parties in the case did not focus on arguments about equal protection, right? The argument that abortion bans violate sex equality norms, the Alito draft does reject that argument, essentially on the basis of precedent, saying that the court in two past decisions, Geduldig versus Aiello and Brave versus Alexandria Women's Health Clinic, had essentially already rejected that argument, and that therefore it was foreclosed by precedent. And so that's kind of an overview. We'll obviously dig into all of the parts of the opinion, but I think that's a helpful kind of look at the different moving parts.
Maybe just to add something as an outstanding summary, I'll just add two contextual points. The first is that the narrow question asked for the court was whether the 15-week ban of the state was constitutional or not. And actually, throughout the briefing and the question presented, we began with a case that really focused on whether viability was the correct line or not. With the passing of Justice Ginsburg and a replacement on the court, things have shifted, and even since the oral argument, I would say shifted even more to this question of the wholesale overruling. The other thing to say, I think, will be there's a way in which you can see, as Professor Ziegler and I, who listened to many of these oral arguments, read many of these briefs over a long period of time, some of the greatest hits on these cases between Justice Thomas and Justice Alito, I think really make it into the draft, whether it's the abortion distortion kind of argument, whether it's questions about egregiously wrong and the like, and questions that were asked. There's a footnote kind of recognizing Justice Thomas's claims in Box about the racially eugenic kind of elements of the abortion law. And there's the one, I think, hat tip to Justice Barrett, which has already been discussed significantly in the media, is the question about adoption as a substitute for these women. And one sees that a little bit in the draft. Would be curious to see whether that's a little bit more prominent or how it changes. But I thought I would just highlight kind of those pieces as well.
Yeah, and one other piece I forgot to highlight that's also worth emphasizing is there's sort of a disclaimer in the draft where essentially Justice Alito says, if you're worried about other substantive due process opinions on, marriage equality or on birth control or on same-sex intimacy, don't worry about it because abortion is sui generis. Roe and Casey involved the taking of a fetal life. Fetal life is valuable. This is different. We're not revisiting any of those precedents. So I think a variety of commentators have weighed in on whether that disclaimer is to be believed or not, but it's also worth putting out there that it's a major part of the draft, right? That this is supposed to be a draft about Roe and Casey and not a kind of, potentially putting out its tentacles into the world, even though, as Professor Cohen says, there are a lot of greatest hits in this, both from, I think, Justices Alito and Thomas, but also from lawyers who work in the pro-life or anti-abortion movement who've been saying these things even before Justice Alito and Thomas did.
So a lot to unpack there in the answers that you two have given me. Before I start unpacking it, I want to say if Glenn's comments on Justice Barrett's framing of adoption as a reasonable alternative to abortion, maybe a socially preferable alternative to abortion, are something that intrigue you. On the Bill of Health, we are right now running a digital symposium on the framing of adoption as an alternative to abortion. So please check that out. Now to unpack the very expansive answers that you have given me. Mary, you're a legal historian. I want to ask you, how unusual is it for the court to say, okay, this constitutional right that we thought existed, turns out we were wrong. It doesn't exist. We're sort of pulling back from that. Is this something that happens routinely? Is this unprecedented? Where does it fall on that scale?
It's certainly very unusual. I mean, the only right that obviously occurs to me that the court had overruled clearly was the right, in Lochner, the kind of freedom to contract right, which in many ways seems dissimilar from the abortion right, because often, in effect, I think Lochner disputes boiled down to disputes between employers and the state rather than employees and employers or others. Certainly there were people who were employees who invoked Lochner rights to their benefit, but often those cases were litigated when employers were violating, minimum wage or maximum hours laws, not so much by people seeking to advance their own concept of liberty. So I think in some ways it's either close to unprecedented or unprecedented. It's not very often that you see a court or this court undoing rights that were viewed as constitutionally central for half a century. So it's certainly something that's noteworthy. And I imagine that, as a historian, that people who don't know of many Supreme Court cases in another 50 years will probably remember this one. So it's a pretty big deal.
I'll just add that, and this is a defensive move by Justice Alito, that I think it's footnote 47 of the opinion lists maybe 13, yeah. 14 cases where the court has overruled itself in the past. Actually more than that, it's maybe 25, 30, I haven't counted, including Swift v. Tyson being overruled by Erie, which is a civil procedure professor. It was kind of, amusing to see that. Now, arguably, some of the way he characterizes those cases, so for example, Payne v. Tennessee, he says the Eighth Amendment does not erect a per se bar to the admission of victim impact evidence during the penalty phase of a capital trial as an example of an overruling. And maybe you could see that as a constitutional right being taken away to some extent. But I think it's quite clear that this is hard to think about another case where something that's been relied upon by a segment of the population as a basic and fundamental and sort of right suddenly has gone away. This is quite sui generis.
My next question actually picks up on something that Mary mentioned earlier in her framing remarks, which is kind of preemptive response that no, the right to abortion, the right to reproductive control is not an equality right. We're not talking about gender equality here. And Ruth Bader Ginsburg famously had expressed her view that Roe should have been about equality rather than about privacy. Do you think if we had gone down that path, the Ruth Bader Ginsburg path 50 years ago, that we would be sitting here in the same place, or do you think that might have had more durability?
I mean, I don't think it would have mattered, because I think that if you've studied probably more than I should have studied the history of this issue, it becomes quite clear that people who are opposed to abortion are not opposed to abortion and don't think Roe was wrong, primarily because its reasoning was unconvincing. They think that Roe was wrong because of the outcome it reached, right? I mean, the right to life movement exists, predated Roe, will post-date Dobbs. And so I think certainly it would have made the job of a court intent on reversing Roe more difficult. But I think that the political machinations and social movement organizing around abortion that I think have helped lead us to this moment, whether that's in terms of legal organizing, political organizing, or grassroots organizing, it wouldn't have mattered. And I think in part you see that in reflected in the draft, in the sense that the draft disposes of the equal protection argument, which I think many in the academy view as the more sophisticated argument. It's certainly the argument in which a lot more professors have invested time and energy in recent years, is disposed of very briefly by, ironically, by citing precedents, including Geduldig versus ILO, which is one of the precedents that I think comes in for a lot of criticism in the academy. So I mean, obviously, to be fair to Justice Alito, the parties in this case were not centrally focusing on equal protection. They were focusing on defending Roe and Casey on their own terms. And so it's possible to read the draft's kind of casual dismissal of the equal protection argument as a reflection of how this case was litigated. But I think that the organizing that's around this issue has given us a court that thinks there is no abortion right, full stop, on any grounds, including ones not originally dealt with in the Roe opinion.
And I'll just add, because I think we're already seeing a little bit of the Monday morning quarterbacking on the briefing and arguments here. And so, first of all, having been an advocate, an appellate advocate, you know, it's always very easy to kind of look back and say, should have done this, should have done that, right? So already we're seeing, should there have been more space devoted to originalism? One thing, first of all, is I think you need to look at the entire kind of corpus of what's before the court. I thought the equal protection arguments were put pretty well in an amicus brief that Melissa Murray, among others, I believe, authored. But the second is just to say that, you know, and so this is a little bit of a tragic thing to say, but I think, well, I should speak for Professor Ziegler, I'll just speak for myself. While the opinion is in some ways surprising, it is kind of a natural apogee of the directions that we were going in a number of ways. And this is a case where I don't think, oh, if we'd only made this argument, or if we'd only written this, it would have made any difference, that this result was fairly baked in. I think the real question was whether it was baked in a coup de grace, one-off, or baked in a series of 5 or 6 opinions over 10 years to get us there, right? And that's the thing that's, I think, that the open question after the Dobbs oral argument. But I don't know, Professor Ziegler, you might have a different view.
No, I totally agree. I mean, I think I would say it was baked in probably since Brett Kavanaugh was confirmed to the court, certainly since Amy Coney Barrett was confirmed to the court. So to the extent there have been any surprises, it's maybe been the speed with which the court delivers, or is going to deliver, probably, if this draft holds, that coup de grace. But I mean, the fact that it's happening, given the broader historical and political context, is utterly unsurprising.
So I'm reminded of a similar event that we had in the fall. And at the time, talking to you about, okay, what do you expect out of Dobbs, for example, when you read the leaked opinion, were you taken aback? Were you expecting it to kind of focus on that 15-week mark and maybe the arguments about viability? Or were you like, yes, this was the way the court was inevitably going to go, they just sped up the process a little?
I mean, I thought this was inevitably where the court was going to go. I was a little surprised that it was Justice Alito taking us there, because I thought there would be more kind of damage control, or kind of an effort to be kind of more empathetic or kind of managing institutional perceptions in the draft, right? I thought that while the draft would inevitably overrule Roe, that it would be done in a way that was intended to show, you know, profound respect for people with differing views on abortion. If in that kind of draft, I would not have expected Justice Alito to be the author. Justices Alito and Thomas have been, I think, the most derisive of Roe in the past, and that much of that kind of scorn comes through in this draft. And so I was a little bit surprised by that. But the kind of broad contours at the oral argument, it was pretty clear that there were 5 justices who thought Roe was wrongly decided and were ready to say so in the near term. I think some people saw maybe some hope or sign or some possibility that maybe Amy Coney Barrett or Brett Kavanaugh could be persuaded by Chief Justice Roberts, who quite clearly wanted to land on a kind of narrower ruling centered on viability. But there really wasn't much sign at the oral argument that anyone beyond Chief Justice Roberts was interested in that kind of middle ground is the wrong way to put it, but that kind of outcome. And so in that sense, I wasn't surprised. I was surprised by the tone to some extent, but that was about it.
Would maybe just sorry, go ahead.
I was going to ask, because you brought up the arguments themselves, were there any novel arguments in Dobbs to make it such a landmark case, or was it just this was the abortion case at the point that the Supreme Court had a block of justices interested in very aggressively undoing Roe?
I mean, I think definitely the latter. I mean, Carrie Severino, who's I think recently argued that this was a good case because it forced the court to, the court wanted to uphold this restriction, it would at a minimum have to say viability was not an appropriate line. And that's true, of course, but that's true of, you know, many other abortion restrictions into which a lot more work had gone, right? So 20-week bans where there was a much more plausible claim that fetal pain was possible, or so-called reasons bans that outlawed abortion in cases of disability or race or sex selection, or certain bans on key abortion procedures. I think all of those had been more central to anti-abortion or pro-life organizing in the past 10 or 15 years. There were only a handful of states that had 15-week bans. That was not because there were only a few states willing to pass such a law. It was because states, I don't think, saw this as a particularly easy platform for the argument that Roe was wrongly decided, other than that it was a pre-viability ban. But that, of course, was true of 6-week bans, 8-week bans, many, many, many other restrictions. So I think this was just a kind of which case got there first kind of issue, where there were 6 justices who thought Roe was egregiously wrong, and this was their first opportunity to say so. I don't see, from a sort of social movement organizing standpoint, any indication that there was anything special about this case that would have made it particularly compelling to justices who were not already determined to overrule Roe.
I completely agree with Professor Ziegler. I'll just add, and this is in part based on her amazing historical scholarship, that within the anti-abortion movement, right, there have always been fights between incrementalists who focus, among other things, on what are called trap laws, targeted restrictions on abortion providers, versus people who wanted to bring a full-on confrontation between the Supreme Court and essentially these laws, and to push for Roe's overruling. And I think the big change is that suddenly the Overton window in terms of the justices has changed, with the retirement in particular of Justice Kennedy, followed by a number of the other kind of changes to the court's composition. But this case is in some ways unexceptional. Maybe the only thing that I think was kind of interesting from the oral argument, and we get a little bit of a hint in this direction, is that the Amy Coney Barrett line regarding adoption, I think adoption is an alternative. It's there if you look for it. It's there historically in various kinds of briefings. But I think it became slightly, that's the one strand that I think probably gained some prominence in the oral argument compared to what I would have expected.
Mm-hmm. Yeah, I would agree with that too. That's not an argument you saw as much in the movement world until Justice Barrett lifted it up.
I want to pull our first audience question, and I also want to remind our audience, please send in your questions using the Zoom Q&A feature. We'll be asking them all throughout this event, no need to wait. But one of our attendees wants to know, many of the newer Supreme Court justices during their Senate hearings said that Roe was settled law, And he would like to know, if they vote against Roe, have they committed perjury during their Senate hearing?
I'll say no. First of all, I don't know. Yeah, I guess they are under oath, so it could be perjury, which is just to say, so I have a fairly low opinion about these hearings to begin with. And actually, Justice Kagan, when she was Professor Kagan, I think wrote one of the best takedowns of these hearings, and then had to wrestle with that during her own confirmation. But essentially, it is truthful that Roe is settled law, right? But what does it mean to have settled law? What are the conditions to stare decisis? One could have had an exploration in theory of kind of the long discussion of stare decisis and Planned Parenthood v. Casey, which again has a lot of hand-wringing as to why, even if Roe was wrongly decided, it is the law of the land, and that was 1992, 1993, right? So I think that it'd be a little bit different than committing to a particular view of stare decisis and going the opposite way. And the way that why I have such a low opinion is that this is a kind of charade where the prospective justices say this much, and then the senators who have qualms can say that they asked the question, but then they never really kind of press down. And if they press down too hard, the answer will be, I could never take a position on a case likely to come before the court. So to me, it's a failure, but it's a failure of kind of the way in which our confirmation process is set up, not something that I particularly kind of think, I don't know. I'm curious what Professor Ziegler thinks.
No, I think so too. I mean, I think I've written recently about how the confirmation process has changed over time, and even how the types of people nominated have changed over time. But I think this is, as Professor Cohen says, it's a process failure. I mean, I think there's a relatively long-standing tradition of not answering the question. And so the kinds of sound bites you'll see the justices give essentially are things about, settled law and Roe as a precedent of the court that say absolutely nothing about what they're going to do. And of course, that's by design. So I don't know if anyone believed at the time that those were solid commitments not to reverse Roe. I think most people familiar with the Supreme Court confirmation process didn't read those statements that way and couldn't read those statements that way. So I think it's more an indictment of how confirmation processes have changed rather than of the individual justices.
So continuing on this section, which I'm thinking of in my mind, an exploration of the court's legitimacy and perception in the public. In this leaked opinion, as you both mentioned, there's a lot of space devoted to justifying why the court can't care about public opinion, why the court needs to follow the law, and public opinion polls, etc., are not its concern. I want to ask, is that unusual for the court to include in its opinion? Have we seen verbiage like this before, reminding its audience what the court considers and what it doesn't consider?
Yeah, it is unusual, right? I mean, and I may not be thinking of every example, but the one that stands out obviously was when the dialogue between the dissenters and the majority, or plurality in parts, but majority in the salient part of Planned Parenthood versus Casey, where the joint opinion in Casey essentially said, were we to overrule Roe v. Wade under fire, we would be perceived as partisan, and that would do irreparable harm to the court's institutional legitimacy. And Justice Scalia responded in dissent that Roe had done irreparable damage to the court's legitimacy and had given rise to the culture wars and, polarized the Supreme Court confirmation process and just sort of generally done a lot of damage. And so I saw Justice Alito's draft in that regard, kind of responding to that dialogue in Casey about the role of popular opinion and legitimacy. Professor Fallon's work on legitimacy, I think here is really worth looking at for those who are listening, if you haven't already. But I saw that as kind of the debate in which Justice Alito was trying to intervene, and I think very much was channeling Justice Scalia. I mean, it's if you had done kind of like a blind taste test with Justice Scalia's dissent and parts of Justice Alito's draft, you might not know which one you were reading. It was very reminiscent of that. But I think that was because, of course, Justice Alito takes the position I think these positions are in tension to some degree, right? But takes the position, one, that the court shouldn't care about popular reaction, but two, that we should care about popular reaction insofar as Roe is concerned, because Roe produced this horrible backlash that destroyed our culture and our, maybe our civilization, and that's one of the reasons it should be overturned, which of course backlash is a manifestation of public reaction, if you believe that that's true. So I think there was some tension in those different portions of the draft, but I think that was where that kind of concern was coming from.
To me, there's a bit of a saying the quiet part out loud bit here, I think, and it also reflects kind of, let's say, not ambivalence, but lack of confidence in a certain set of the ways in which constitutional law is determinate. So just to put my legal theory hat here on, what's interesting is the way in which kind of the draft leads into legal realism, maybe even critical legal studies in some ways, right, that are surprising in these acknowledgements of these moments of kind of the world outside the court, as opposed to a view, while at the same time protesting that, well, actually the meaning of the Constitution is the meaning of the Constitution, and no amount of social movements or the like changes that there is a true meaning. So I find that kind of internal tension in the opinions, Professor Ziegler says, quite interesting. And my guess is that also, and this is perhaps not unfortunate, but it's a reality, that given that this draft is leaked, chances are this draft will change less than it might have in the ordinary course of things. And I would have been curious to see which of those pieces might have been changed or tonally changed in some of the comments in the circulation between the justices.
So I'm glad you brought up the leak. I understand that neither of you has a particular background in espionage. So I won't ask you
don't
to
speak
speculate.
too soon. No, I'm just kidding.
So I won't ask you to talk about how the leak itself might have happened, but I do want your thoughts on why you think this truly unprecedented leak happened on this particular case.
I mean, my guess is because obviously people are watching. I mean, Roe is by far the most recognized, best known Supreme Court opinion. That means that a decision overruling it will be viewed as more consequential by more people. And I think that in light of that, probably whoever the leaker was concerned either that this would be the draft would be the final draft and was using the leak to try to change that, or was concerned instead that this draft would not be the final opinion and that somebody was wavering and was using the leak to ensure that outcome. But I think the stakes feel higher in this kind of case for the court as an institution, for US politics, in many ways, I think, than other Supreme Court cases, even though I don't want to understate, particularly right now, given the kinds of issues that the court has on the docket, there are a lot of really crucial issues to our constitutional order that the justices have either before them now or in short order. But I think there's a feeling that overruling Roe is different, is consequential, and that the leaker was probably trying to influence that outcome one way or another.
And there's also a question, and again, I think it's good that we're not speculating too much. And I think also there's been a strategic use of conversation not by us and not by academics for the most part, but in political circles, of use of deflecting attention to the leak and the mystery of the leak away from kind of the content of the opinion and its implications, right? But I do think that there is a dialogue now in terms of the electoral chances in November, but also a series of states that have trigger laws, right? That one thing that for better or worse, I think those issues have bubbled to the surface in a period of time in which changes might be made in some of those states in a way that might not have been possible if the opinion was released on the ordinary course of things. So perhaps that's a motivation for someone, but I really have no idea.
So I'm glad that you brought up trigger laws, because I want to move away from the court and the opinion itself to thinking about what the world might look like if the Dobbs opinion does look very similar to the leaked draft. So the first question, which is an audience question, is there is talk that there might be a federal nationwide ban or a fetal personhood bill that would pass. What would the potential constitutionality of that type of legislation look like under this new court?
Yeah, I mean, we would need to know obviously about the bill, because there would probably be challenges if there were a federal law banning. I mean, I think the current proposal would be a federal kind of heartbeat ban, right? So a 6-week ban. Obviously, the constitutional challenges would depend on what, you know, what the bill says and like what congressional authority it invokes, whether it's Section 5 of the 14th Amendment or the Commerce Clause. So it's sort of hard to speculate too much. I mean, obviously, if the court has said there's no right to abortion, it will, the Section 5 analysis would depend on how, you know, what we would imagine to be a Republican Congress would say, you know, its enforcement authority looked like, and whether that was in any tension with what the court had said in its final draft of Dobbs. And whether, you know, for example, Congress is pushing too much potentially for the court in the direction of there being constitutional protection for fetal life, rather than, as Brett Kavanaugh put it in the oral argument, scrupulous neutrality with respect to abortion. And I think similarly, it's sort of hard for me to know how the court would evaluate a Commerce Clause justification without knowing what the argument would be. I think obviously from the standpoint of something like a federal protection for abortion rights, it may be more likely that a court would strike that down, certainly as so far as Section 5 is concerned, if the court has said there are no constitutional protections for abortion, and a federal abortion rights bill took a stand contrary to that, right? But beyond that, it's sort of hard to say, because I think there already are constitutional arguments that in favor of fetal personhood, right? Some of which were made in amicus briefs in the Dobbs case. Those tend to be kind of styled as original public meaning arguments about when the framers of the 14th Amendment thought life began. That will continue. So, I mean, I'm imagining that the Supreme Court will get that constitutional question. Whether they're interested in taking it up or how they view it, I think we'll have a better sense from concurring opinions in Dobbs. But with a federal bill, I feel like I would need more information to know how the court would actually weigh in on it.
I'll just add 2 observations. The first is on the Commerce Clause rationale. One of the things that's interesting is that actually it's the conservative justices that have been the most scrupulous about limiting Congress's power under the Commerce Clause. And that's why I think Professor Ziegler says much easier to imagine them striking down a Biden effort or not future Democratic effort to try to restore Roe v. Wade than it is to imagine how they're going to deal with the opposite configuration. I'll also say there's this interesting question about whether the opinion by Justice Alito is an originalist opinion or not, and the gap between original public meaning, in particular on the one hand, and then a continuation of the line that predates Glucksberg, but is most associated with Glucksberg in terms of, you know, found in the nation's history, necessary for ordered liberty, goes back quite a lot. And there's some interesting, it's sort of, if you're an abortion, if you care about this issue, I think it might strike you as too academic, but if you are an academic, it is actually somewhat interesting debates we're seeing right now on Twitter between like Larry Solom and Randy Barnett on the one hand and others about to what extent Dobbs is an originalist opinion versus not, versus being originalist consistent. And I think some of the issue is that some of the discussion of pre-quickening or the pre-quickening abortions and post-quickening abortions in the long section of Justice Alito may cause some problems from extending the analysis towards a redefinition of fetuses as persons as required by the 14th Amendment. But so much of this is much more politics than it is kind of ordinary lawmaking. So I don't know that I feel confident making a prediction. I'll also say electorally, and this is again something else, while this will be a next frontier for the anti-abortion movement, it's probably a long frontier, the same way getting Roe overturned was a long frontier. That's not a lot of solace to people because things look like they're changing as to Roe as well. But it probably is a project that's going to require many years. That I have no great confidence that even the current justices have that view, but I could be wrong.
So one interesting thing I think about a post-Roe Dobbsian world is that it feels like, assuming that there's no real federal action, that states are going to very much move in opposite directions, that you're going to see a lot of states, such as Texas, that are going to effectively ban abortion, but also create strict penalties for people who aid and abet. And then you're going to have states such as California saying, no, we are abortion havens. We are opening our doors. We are making sure people can come here for these services. How do you see conflict between these state laws playing out?
Maybe I'll start on this one. So in some ways, I think the history of Ireland is our history in reverse in the following sense, right? Ireland begins with a constitutional prohibition or constitutional restriction on abortion. It then faces, with the X case and other cases, questions about women traveling from Ireland elsewhere and the extraterritorial reach of prosecution and the ability to restrict, as well as the ability to restrict speech. Then we get the travel amendment that explicitly permits it. And then ultimately we get a referendum kind of liberalizing abortion law as a constitutional matter in Ireland. We're likely to see exactly the same cases, but in reverse. There have already been states that signaled their interest in engaging in extraterritorial extension of their criminal law. And we have cases that predate Roe as well on this topic, but also cases about referrals and speech and information in those states. And what I'll say is the constitutional structure here, and there's a great paper coming out in the Columbia Law Review by Reboucher, Cohen, and Donnelly on this topic, among others. I think that they are correct in their diagnosis. There was a series of good papers in 1993, I think, by Kramer, Jerry Newman, Leah Bromeyer on this topic, that actually, if you try to read the Privileges and Immunities Clause in Article 4 and elsewhere in the Constitution to get a real sense of what is permissible or not with this extraterritorial extension, it's very messy, it's very undetermined, and we're likely to have significant litigation about it as we go forward if more states end up being muscular. But I wouldn't kind of count out the idea that there's no extraterritorial force of individual states. And I think there are interesting questions about your views of federalism. Like, I often offer people conversion therapy as kind of an interesting comparison case. So states that tried to ban providing conversion therapy, they've banned it territorially, but tried to ban it for their citizens outside of the territory. That it's an interesting kind of test case to say, do we have strong views about what the role in federalism of the extraterritorial extension of criminal law ought to be?
Yeah, I completely agree. I think the constitutional questions that extraterritorial application of criminal law would raise are really unsettled vis-a-vis the right to travel or the Dormant Commerce Clause. Even the choice of law questions are extremely unsettled. But it seems that states are interested in this, and it's not surprising why. I mean, it's worth sort of asking, because it's not straightforward why this is happening now. I was curious when we first began to see states making this move, if states had made this move in the past. And I haven't done an exhaustive look, but based on the research I've done on the 80s and 90s, when people thought Roe was going to be overturned, that was not something that anti-abortion or pro-life groups were focusing on. So I think what's changed in part is that the abortion rates already declined significantly in a lot of red states, and it has not declined in large populous, mostly blue, but sometimes purple states like New York, California, and Florida. And so I think there's a real awareness in conservative states that unless you have extraterritorial application of laws, the laws will have a gaping loophole, right? And in many instances, the abortion rate will not go down even in a post-Roe United States. So I think that's why we're seeing this, but I think it's likely to usher in a probably even more chaotic era legally than the one we've come to know.
And if I can just add one more note to that, which is from a reproductive justice perspective, it's really important to kind of recognize that while travel for some women is an option and a possibility, for many women, it's either not a very good option or it's not an option at all. If you're a person with a disability, if you're a person with a job or have other childcare needs and can't get away, if you're in a relationship where you fear domestic violence if you leave for a period of time and this is kind of discovered, right? Just then putting aside just how far some women will need to travel and how expensive it will be, right? So that's just to say that I don't want anybody to think that we're suggesting that even if this is permitted, that this is an easy solution. But what's interesting is that there is a real appetite, I think, now to look into the next frontier for the anti-abortion movement. And this is one of the next frontiers in a way that I think it was so far off that I don't think it was something that we really were seeing active legislative moves whereas they're taking their cues from the court and from the president, and from the composition of state legislatures and federal legislatures.
So moving from a discussion of federalism, the next big area of impact I want to talk about is reproductive technology. For example, there is a reproductive endocrinologist working in Texas, actually, Natalie Crawford, who is very kind of publicly online, and she tweeted out very frequently about her concerns, writing, "Today in IVF monitoring, almost every patient asked how overturning Roe will impact their potential embryos or future fertility attempts. Let that sink in. Infertility patients who strongly desire pregnancy may be limited in the ability to pursue IVF to grow their family." Are Dr. Crawford's patients correct in having these concerns?
Maybe I'll start with this one, if that's okay, Professor Ziegler. So in some ways, I'm going to give this person and other people worse news than the news they already have, which is, if you look at the history of opinions discussing the ways in which the right from Roe, recognized in Roe, protects reproductive technology use in the United States, you'll find vanishingly few opinions. The opinion in JR v. Utah, which is in the early 2000s, about Utah surrogacy, a district court opinion, one of the few that comes to mind, which is just to say the constitutional status of the right to IVF, the right to dispose of embryos and the like in the course of reproductive technology use has never been something that's kind of been very full-throatedly articulated by the courts. And there's a lot of reason to think that even before Dobbs and the Dobbs decision, it was going to be a hard-fought battle if you had a state trying to contravene it. What was interesting is that relatively few states had tried to restrict it. You know, we have Louisiana that has a statute on the books relating to embryos as juridical persons and questions about disposing of embryos in Louisiana, and you have restrictions on surrogacy in particular. But for the most part, the restrictions on IVF have been relatively few and far between in the United States. Now, so the question, I think, the question to ask is not so much the constitutional question, did you have a right yesterday that no longer exists, but whether states are going to be emboldened and feel pressure to make inroads on IVF and on embryo destruction in particular after this opinion. And I think that's a hard political question. So one case in point is Mississippi had a referendum on personhood amendments. And the way they phrased it, I can't remember whether it was conception or fertilization as the operative term in the statute, raised some opposition, including by oppositions by people who used IVF or new people who used IVF, which is to say the population of people who use IVF and want to support IVF, it does not necessarily overlap with those who are only pro-choice, right? There are some in the pro-life movement. It's a much more, I think, nuanced sort of thing. What's more likely to happen, in my opinion, is not that we'll see legislation directly targeting IVF, but rather poorly drafted legislation sideswiping IVF and questions of interpretation of those statutes. So then in the zeal to kind of restrict abortion, statutes will be framed in a way that sideswipes reproductive technologies. And then there'll be a question for me, more of a political question, a legislative drafting question about whether constituencies in favor of those technologies are able to get the language changed. But I'll be curious to hear what Professor Ziegler thinks.
Yeah, I think historically there's always been much more than most people appreciate. The meaning of the word abortion has been contested. That's true, I think, most visibly with respect to contraception, which we saw in debates about the contraceptive mandate to the Affordable Care Act. But it's been true with IVF too, and there are in fact some pro-life groups, including in Texas, where leaders of anti-abortion groups have openly expressed concerns about, if not the entirety of IVF, then steps taken in IVF, including selective reduction. So sometimes to maximize the chances of a successful pregnancy in IVF, doctors will implant multiple embryos to maximize the chances that one of them will come to term, and then will terminate one of those pregnancies, again, for the same reasons, to ensure, if possible, that one pregnancy at least is successful. There are some in the anti-abortion movement who unambiguously see that process, selective reduction, as abortion. So you may see scenarios where states draft, as we've seen this Louisiana bill, language suggesting that life begins at fertilization without exceptions for IVF. you may also see states affirmatively saying that IVF needs to work differently if it's not going to include abortion, because there are some in the anti-abortion movement who are uncomfortable with steps in IVF or with IVF in its entirety. And I think this is one of many areas. I think the punishment of pregnant people is another, where there's a real debate in a lot of red states about how far to go and what the right kinds of policies look like. That really is just beginning, because I think that the preoccupation in those states had been just the dismantling of Roe. There really hadn't been a serious conversation as much about what an ideal policy looks like. And so I'm not sure how those conversations are going to play out. We have seen both, I think, the kinds of drafting Professor Cohen suggests, where we've seen some states essentially call out that they are not regulating infertility tech treatment. And we've seen other states essentially drafting language that's either sloppy or intentionally open-ended to probably bridge divides within the anti-abortion movement in those states.
The next area I want to turn to is travel for reproductive services. Professor Cohen, you are an expert on medical tourism, although usually in the context of traveling outside of the country to a completely different country, and not necessarily traveling from state to state. But here, I would love to hear both of your thoughts on cross-border, meaning most likely state, although perhaps some travel to Mexico, Canada, etc., for abortion services, and perhaps for other services such as IVF. And here, perhaps one twist, I also want to throw in telemedicine as a service that transcends borders. So either you're bringing the patient to the physician, or you're bringing the medical care to the patient across the border.
Yeah, maybe I'll start with the telemedicine, because I think I said a little bit of my views about the travel earlier. And that's just to say that I think one question that will likely be a soon to be decided legal question is actually, and again, for the law students in the audience, one of the things that I think is so interesting about how bioethics debates get resolved in the court system is that often they turn on doctrines that have very little to do with bioethics, right, formally speaking. So here, I think many of the most interesting questions are preemption, and to the extent to which FDA's approach to the drugs in question, Prestone and Crystal, whether that plus the REMS that's in place as a matter of FDA law, at least one of the drugs, ends up being preemptive or not about state attempts to restrict prescribing or the availability of the drugs. And here, I think this is also an undetermined area, but an undetermined area of FDA preemption. And actually, some of the most analogous cases are not from abortion at all, but involving opioids and opioid-resistant formulations in Massachusetts, which at one point tried to go its own way and depart from what FDA had said. So I would say, if you wanted to learn about an area of law that might help you to litigate these cases or think about these cases, that actually questions of preemption are likely to be high up there as a legal matter.
Yeah, I mean, I would echo that. I think that there are, I think the other interesting question about the sort of intersection between medication abortion preemption and generally questions of travel is the extent to which that changes the dynamics of whom states set out to punish. We've seen thus far that, with the possible exception of Louisiana, states have been pretty in lockstep in saying they seek to only punish medical professionals and potentially aiders and abettors, which is a kind of broad category that could include theoretically almost anybody but the pregnant person. But I think that the availability of medication abortion and possible steps involving FDA preemption will put, I think, especially just even the availability of medication abortion, more pressure on states to consider punishing patients, because I think it will often be difficult from a variety of standpoints, including the willingness of states to extradite, which we've seen Connecticut already signal that it will not extradite doctors. I think the availability of medication abortion may change the dynamics of who the target of criminal prosecutions is likely to be. I'm not sure if that's going to happen, but obviously there are real tensions created by the availability of medication abortion that we have yet to see play out.
And maybe I'll just add, from the perspective of people who believe abortion should be criminalized, right? It's easy to understand why, if you believe the premises that underlie that argument, relating to fetal personhood and the idea that women's rights of autonomy do not trump fetal personhood, it's a little hard to understand why you would not want to try to go beyond your territorial boundaries when you're talking about a fetus that is a citizen of your state, right? So in some ways, not only do I predict this to be the next battleground, in some ways it's understandable as the next battleground within the viewpoint of the people who have these premises that they believe in.
So knowing that we only have a few more minutes with you two, I want to combine two forward-looking questions. The first is, do you see this issue as a pendulum that maybe in 50 years we'll be having a similar conversation about a liberal court that is undoing Dobbs and restoring Roe? And in the meantime, what harm-reducing legal strategies remain available or feasible for reproductive justice advocates, given that Dobbs rejects liberty grounds and points to the foreclosure of equal protection grounds? Two great questions from our audience.
Why don't I give Professor Ziegler the last word, and I'll just very briefly answer, which is to say, in terms of strategies, state legislatures fighting about gerrymans in these states, that to me, that is the place where the most energy can now be focused, I think. In terms of a liberal court, it's hard for me to imagine this not becoming kind of a crusade on the left now to overturn Roe, to overturn Dobbs, I should say, the same way it became for Roe. So I would, expect this to be a likely future. And if anything, we look at examples like Ireland and Mexico, most of the world is moving in that direction. So it's sort of surprising that we've gone in the opposite direction.
Yeah, I mean, as a historian, I think I'm often asked the question, what will it take to make this stop? And the answer, I have no answer, because I don't think and the answer is certainly not the Dobbs opinion. So I think that in 50 years, we'll be talking about this again. And I think I agree with Professor Cohen that there are lots of ingredients here for an effective counter movement to reverse Dobbs if you're looking in the long enough term. Obviously, I think that's a question of decades, not of months or years. So I think federal constitutional law is something that will be changeable only if people are playing the long game. And if they're playing the long game, not just in terms of constitutional theory, but in terms of social movement organizing, political lobbying, the kind of restoration of something that looks like a genuine grassroots pro-choice movement, which I think has been underdeveloped in recent decades. And that's true even, I think, of a kind of frayed relationship between the movements for reproductive justice and a right to choose. I think the action at the moment is in the states. I would suggest, state constitutional law is a potentially untapped resource. We're seeing that play out already. Certainly in Michigan, that's probably the main theater where we see that playing out now in multiple, I've sort of lost track of the number of state constitutional challenges currently unfolding in Michigan, as well as sort of Ireland-style direct democracy measures that are presented to voters in states that have majorities that seem to want abortion to be legal under all or most circumstances, that also seem to have legislatures or pre-Roe laws in place that would criminalize most abortions. So I think that kind of initiative, similar to the one we ultimately saw in Ireland, would also be interesting. Ironically and interestingly, people who are, people on the other side of the issue who oppose abortion are also sometimes pushing for kind of direct democracy measures like we're seeing in Kansas. So I think that's another area. But I think increasingly action will be at the state level and even at the local level, right? I mean, some of this is going to come down to how much individual prosecutors are willing to commit resources to the prosecution of abortion cases, how individual prosecutors interpret ambiguous laws like the ones Professor Cohen flagged earlier. And I think, so more attention to state and local government, more attention to state constitutional law in the short term would really be wise.
Well, with that, I think we are at time, but thank you both for your very thoughtful reflections on this issue. I feel like you are both such professors in that you have given us a laundry list of cases and good articles to read to get a better contextual understanding of Dobbs and a better understanding of how the next steps might play out across the country. So thank you very much. And we will likely talk to you again when the official opinion is handed down.
Thanks for having us.